Hello friends, welcome back. So we are going to summarize our discussion on one of the most important areas of Indian Contract Act. We were discussing what is required for an agreement to become a contract, correct? And we had seen that you need agreement plus some conditions to be fulfilled, and then only you can have a contract in place. In very simple terms, what you need is agreement. We know is offer plus acceptance plus consideration, correct? Firstly, we will need all these elements. Then once we have an agreement in place, we will need to fulfill a few conditions. Now, what are those conditions? Number one, we saw that parties who are entering into the agreement should be competent to enter into the agreement, correct? Secondly, we saw that both the offerer and the offeree, which means the parties to the agreement, should give their consent voluntarily or freely. Third condition, and in free consent, before we jump to the third condition, in free consent we saw 5 elements, right? One was coercion, second was undue influence, third was fraud, fourth was misrepresentation, and fifth was mistake. The third condition that we had seen was lawful object and lawful consideration. It means that the purpose or the goal of the agreement should be to do something lawful. Alright? Similarly, the consideration that is being provided by both the parties, that consideration also needs to be lawful. Today we are going to look at the last condition. And when you have all these conditions, then you can safely say that an agreement is now a contract. And what is the last condition? The agreement should not be expressly declared to be void or unenforceable under Indian Contract Act. It means that there are certain types of agreements which are mentioned in the Indian Contract Act itself, and the act itself tells you that these kinds of agreements are void or not enforceable. So that is the last condition, that even if you have an agreement, but if that agreement has been declared to be void by the Indian Contract Act, then such an agreement is not a contract. Now imagine someone tells you this: I will give you rupees 1 lakh if you promise never to marry. Let's say somebody tells you, I will give you rupees 1 lakh if you promise never to marry. So basically you're promising that you will not marry in this lifetime, okay? You take the money and after a few days you get married. You take the money and after a few days you get married, which means that you have broken your promise. Now the other party wants to sue you for breach of this agreement. First question, is this an agreement? To determine whether this is an agreement or not, what do you need to check? You need to check 3 things. First, is there an offer? Second, is there an acceptance? Third, is there consideration? Let's apply this. Is there an offer in this scenario? The answer is yes. What is the offer? Somebody is making you an offer to pay rupees 1 lakh to you in case you promise not to marry. So that is the offer. The offer is that if you don't marry in this lifetime, I will give you rupees 1 lakh. Is there acceptance? The answer is yes, because you accepted. And is there consideration? Consideration is price of the promise. One party is promising that I will give you rupees 1 lakh. Second party, which is you are promising that you will not marry. Which means that we have consideration from both the sides as well. So this is an agreement because we have offer, acceptance and consideration. But you will be surprised to know that this kind of agreement is void. Why? Because Indian Contract Act says that this agreement is void. Now with this background, let's look at a few types of agreements. We are not going to discuss each and every type. A few important types of agreements which the Indian Contract Act explicitly declares to be void. So let's make this heading: agreements declared to be void by Indian Contract Act. We are looking at only some relevant types of agreements, not all. Alright. First is agreement in restraint of marriage of a person except a minor. Now what this is trying to say is that if there is an agreement which prohibits a person from marrying, okay, now that agreement is void. And the only exception is you can have such kind of agreement restricting the marriage, but only for minors. So you can restrict the minors from marrying. There's no problem with that. And you would know very well that in India, the legal age to get married is 21 years for a boy and 18 years for a girl. So this is perfectly fine if there is an agreement in place restricting the marriage of a minor. Minor is somebody who is below 18 years, right? However, any prohibition on marriage of a major, which is a person who is 18 years or above, that agreement is void. Okay. Now let's understand. I already gave you one example. I'll give you one more example. So there are two people, A and B. Okay. A tells B that if you, let's make it three people, A, B and C. B is a boy, C is a girl. Both of them like each other and they want to get married, B and C. And A is C's father. Okay. A tells B that if you promise not to marry C, I will give you rupees 10 lakhs. All right. Now, B takes the money and does not marry C. So he has fulfilled the condition. But he marries another person, D. So I have one question here for you. There are two scenarios. One, the first scenario that we discussed was a complete prohibition on marriage, which said that you cannot marry anyone during this lifetime. In this scenario, A, B, and C, there is a partial restriction. Restriction is only vis-a-vis C, which means that B cannot marry just one person, which is C. There is no other prohibition. So B can, as the agreement does not prohibit B from marrying anybody else other than C. So question, is this agreement void or is this agreement valid? The answer is, even if there is partial restraint on marriage, the agreement becomes void. And please pay very close attention and remember this. Many people get confused. They think that, okay, B is allowed to marry somebody else, which is D. And therefore, the agreement should be perfectly fine because this is not a complete prohibition. But please remember, law clearly says that any prohibition on marriage of a major who is 18 years or above, that agreement is void. Alright? So don't get confused between complete prohibition and partial prohibition. Now let's look at the second type of agreement, which the Indian Contract Act declares to be void. Agreement in restraint of trade. Okay, let's discuss this below. Agreement in restraint of trade. What does it mean? It was in news also a couple of years back where one company, a leading IT sector company, what they did was, in their employment contract, and I'm sure you would understand what an employment contract is. Whenever you join a company, you are given an offer letter and thereafter an appointment letter is also issued, correct? And there are certain terms and conditions mentioned in that letter governing the relationship between the company and the employee. Now, one of the terms in that employment letter was that after leaving the job, let's say you're working with a company XYZ. After leaving XYZ, you cannot work with a competitor of XYZ ever in your life. Question, is this agreement valid or is this agreement void? The answer is this is void. Why? Because ICA, Indian Contract Act, clearly says that any agreement which is in restraint of trade, business, occupation. Here trade means, please remember, here trade means any lawful profession, any business that you do, any job that you do, lawful profession, trade or business. It includes all these means of livelihood. It doesn't matter like what your means of livelihood could be. Business, your means of livelihood could be a job, your means of livelihood could be trade. It's all of those things would fall under the term trade here. Indian Contract Act says that there cannot be any prohibition in restraint of trade, which means that the law does not want people to suffer. It says that everybody has a right to livelihood, correct? The logic of this restraint is everyone has a right to livelihood. Now let's say if I'm a lawyer and I've worked at a company in my capacity as a lawyer and they tell me that you cannot work with a competitor ever. And let's say I'm a banking lawyer, okay? And I've worked for a bank. I cannot go anywhere else. I have to find another bank only. And if my previous employer tells me that I cannot work with a competitor ever in my life, what happens to my livelihood then? I'm going to suffer, correct? So that is why law says these kinds of agreements will be void. However, there are some exceptions. What are those exceptions? First of all, what kind of exceptions? Law says that any restriction which is reasonable restriction, you might have heard this term in constitutional law, that freedom is not absolute. Okay, there can be some restrictions, but those restrictions have to be reasonable. Reasonable restrictions could be there on trade. Example, let's say notice period. Again, you might have heard of this term, that once you quit, then you have to give notice for a few days, serve notice for a few days. Now you may say that, look, I don't want to work with this company. Why are they making me serve the notice period for another 2 months or 3 months? Your notice period could be 15 days, 1 month, 2 months, 3 months. Notice period is basically a time which starts from the day you submit your resignation till your last day with the company. And the logic behind notice period is that, let's say if you're working for me and you quit one day suddenly, I will not be able to plan transition, right? I will need to hire somebody else as your replacement. I will need to train that person, or I will expect you to give a handover because I was not involved in the activities that you did. You were the best person to know everything about your job, correct? So that is why we have notice period, which gives the employer a certain timeline to plan the transition or to move on from an old employee to a new employee. Now this is a reasonable restriction, provided the notice period duration is reasonable. If somebody tells you that your notice period is 3 years, is that reasonable? The answer is no. Notice period can range from a few days to a few months, depending on your job profile. It cannot it cannot be like 1 year, 2 years, 6 months. That will be excessive. But again, all of these things are subjective. You will have to apply your mind. What seems reasonable here? If I work as a teacher for an institute and they tell me that your notice period will be 6 months, now that will be excessive, right? Because I'm not handling anything which is too, or in other words, I'm not handling anything which is a trade secret. And we will come to that. That in certain industries, you might have seen McDonald's or let's say Coke recipe. There are only a few people who know the recipe, okay, that how is the burger made, how is this Coke made. And there can be notice period requirements which can run to, let's say, 6 months, 12 months, or in those scenarios. One example that I gave was of notice period. Second was of not joining a competitor. Not joining a competitor for a limited duration. So let's say if I work at Coca-Cola and I know their secret recipe for Coke, after I quit my job, they may tell me that you cannot join Pepsi. Okay, you cannot join, let's say, assuming Pepsi is a different company. I don't know whether Pepsi is different from Coke or not, but assuming Pepsi is a different company, they can tell me that you will have to wait for 6 months before you join Pepsi. Okay. And in addition to that, they may make me sign a non-disclosure agreement, which is also known in the legal world as an NDA. The objective is that I may join a company, I may learn some trade secrets, okay? Now, I can benefit how? By telling other companies that if you take me in, or if you give me this much salary, then I will reveal the trade secret of my employer with you. Do you think that's fair? The answer is no. And therefore there can be reasonable restrictions. So what all did we see till now? That the general rule is that there cannot be any restriction on livelihood or trade, correct? The only exceptions are those which are reasonable in nature. And we saw two examples. One is notice period, when you quit a company and you have to remain with that same company for a limited duration so that the company can plan transition. Second example, not joining a competitor for a limited duration. Again, please focus on the term limited. If the duration is limited, and if that limited duration is reasonable, then that restriction is valid. That will not make the agreement void. There can be a limited duration. They can also make you sign a non-disclosure agreement or a confidentiality agreement, saying that whatever you learned in this company, you cannot disclose it to anybody else. Now, those are said to be valid restrictions. All right. Any restriction other than these reasonable restrictions on trade would be considered as void. So remember this agreement in restraint of trade. Third example of an agreement which has been declared to be void by Indian Contract Act. Agreement in restraint of legal proceedings. Let's say you and I sign an agreement, okay? Or let's call the parties A and B. A and B sign an agreement. Agreement says that even if there is a breach of the agreement, the parties cannot go to the court. The parties cannot go to the court, and they will have to resolve the dispute between themselves. Okay, I hope you understood what I tried to say. So basically, A and B are saying that, okay, both of us are signing an agreement, but we do not want to go to the court. We do not want the hassle of court proceedings, even if there is a breach of the agreement by one party. Question, is this valid? Is this kind of agreement valid? Now, before answering this question, think like this. Can there be a restriction on legal rights? Can there be a restriction on legal rights? What is your legal right in this scenario? When an agreement or a contract is breached, what is your legal right? What is the legal right when a contract is breached? Your legal right is to approach a court of law, correct? For enforcing the agreement. What if the agreement takes away this right from you? For example, let's say you join a reputed coaching institute for CLAT, okay? And whenever you join any institute in India, you will have to fill some form, or you will have to sign on a piece of paper, okay? Now, let's say one of the terms of that paper is that even if the institute does not fulfill its promise you are prohibited from going to the court. You cannot essentially go to the court, even if the institute does not fulfill its promise. So if the institute told you that we will give you, let's say, books for each and every subject, we will give you 1000 hours of live lectures, we will give you regular mocks. Okay, all of these things are promised by the institute. But you signed on that piece of paper without reading it. And one of the terms in that letter was, or on that paper, on the paper was, that even if the institute fails to fulfill its promise, you are prohibited from going to the court. And both you and the institute have agreed, right? Because you have signed on that piece of paper. You, assuming you are a major, or if you are a minor, then your parent or guardian. Now there is an agreement. Both of you have agreed that even if the institute does not fulfill its promise, you cannot go to the court. Question: can you really not go to the court? Just because you signed on a piece of paper which stops you from exercising your legal right? First question is, what is your legal right? If the institute does not fulfill its promise, what is your legal right? Do you have a legal right to go to the court? The answer is yes, you have. Can the coaching institute prohibit you from doing that by making you sign on a piece of paper? The answer is no. And therefore, we say that agreement in restraint of legal proceedings is void. What you cannot be stopped from or prohibited from exercising your legal rights, even if you sign an agreement to that effect. The limited exception is that of arbitration, mediation. Okay, we are going to learn all of these things. These are alternative dispute resolution mechanisms. So all of us know that courts are very time consuming, costly, and it's a very lengthy procedure. So what most people do is that they agree for some alternatives, that if a dispute arises between us, then what is it? Can we opt for any other dispute resolution mechanism other than going to the courts? The answer is yes. We can go for arbitration, we can go for mediation, we can go for conciliation. And in India, this is backed by a statutory mechanism. So we have a law for this, Arbitration and Conciliation Act. So there is a proper law which allows party to go for arbitration or conciliation. Okay? The limited exception is this. So you and I can sign an agreement where, or let's take the coaching institute example. Coaching institute can say that if the coaching institute does not fulfill its promise, you cannot go to the court, but you can go to an arbitrator. You can initiate arbitration proceedings. There you cannot say that, no, this is in restraint of my legal rights, because you agreed for arbitration. Okay, and many a times you will see that whenever you choose arbitration proceedings, you will find one line in the agreement that the decision of the arbitrator is final. After that, you can appeal it, but only on very limited grounds. You cannot go to the court with a very, let's say, weak ground. You have limited options to appeal. So can you say that, no, you're stopping me from going to the court, therefore this agreement is void? The answer is no. When you opt for these mechanisms, arbitration, mediation, conciliation, when you have accepted these alternative dispute resolution mechanisms as a form of dispute redressal, then you cannot say that this is a restraint on your legal rights. All right. This will apply. Agreement in restraint of legal proceedings will apply only when there is complete prohibition. Arbitration, conciliation, mediation is also a kind of dispute redressal mechanism, and therefore they are not called complete prohibition. All right. So I hope you understood. Another example is, you might have heard of one act in India which is known as Limitation Act. of 1963. So what it does is, let's say today, between the coaching institute and you, the same example, coaching institute does not fulfill its promise in 2026. You file a case in 2050 after 24 years. Can you do that? The answer is no. You cannot file a case in 2050 because Limitation Act tells you time within which you have to file the case. Okay, and it tells you Limitation Act has different categories. For breach of contract, it says that you can file a case within 3 years from breach. Okay, whenever the breach has happened, from that day until 3 years, you have this much time to file the case. So if you go after 24 years, the court will not accept your case unless you can show the court a compelling reason as to why you could not file your case in the 3-year timeline. Now my question is, law gives you 3 years, right, from breach. What if, again, that same piece of paper which the coaching institute made you sign, what if the coaching institute says that if you have to go to the court, you can go to the court only within 1 year from breach? So coaching institute is restricting the timeline. Okay, law gives you 3 years. Coaching institute has given you 1 year. Which will prevail? Of course, you would say that law has to prevail. This 1 year period is not applicable because this is a restraint on your legal rights. The law gives you a right to approach the court within 3 years. Coaching institute cannot limit it to 1 year. So you have to remember this. All right. So this was the last category, agreement in restraint of legal proceedings. There are other types of agreements also. We will not be looking at each and every agreement in detail. In the next class, we are going to talk about some specific types of agreements like wagering agreements, contingent agreements, insurance agreements, etc. So I hope by now you have understood that we started with offer, acceptance, consideration, correct? And all these together make an agreement. Then our next goal was to understand what is a contract. And we saw that agreement plus some conditions, when fulfilled, then only we have a contract. And I told you about all the conditions, right? All 4-5 conditions we discussed in detail. Now, I would like you to revise this because by now, I'm sure if you've attended the classes properly, you have a fair understanding of what is a contract and what is not a contract. So, as I said, from tomorrow we are going to look at specific types of contracts, but until and unless you understand what is a contract, it will be very difficult for you to understand the types of contracts. All right. So please go and revise the lectures, revise your notes, whatever, like if you have made notes and all. And I'm going to see you in the next class. All right. Thank you so much.